Your Honor, may the people speak.
Yes, I guess I forgot. I thought
Thank
I
you.
heard from you, but it was not in full.
When I originally spoke with Mr. Nussinger regarding the MDOP case, um, one of the things that I indicated I would be recommending this morning, because I had chosen to leave the deferral in place on the domestic violence case to allow him an opportunity to have a non-public record of a domestic violence charge, that I wanted him to do 5 weekends in custody. And my reasoning for that is that I'm dismissing a second domestic violence charge that happened when he knew he was pending sentence in this court for domestic violence against his mother. I want him to be able to maintain his employment, which is why I'm recommending weekends. But I don't believe that you can plea and be pending sentencing and on bond conditions and commit a new violent offense, still have the benefit of a deferral and not have an additional sanction. So I am requesting that at least 5 weekends in custody be part of the sentence up front, so that he has a very stern reminder that if he does not comply with all the terms and conditions of a deferral probation, not only does he risk losing that deferral status, but he risks additional jail time for non-compliance. He wasn't able to abide by the bond conditions of not committing a new crime. Thus, he needs to have a sanction for it. Beyond that, I do recognize he has some mental health conditions. He has sought assistance that's pivotal to get the appropriate prescription medication for his condition. He's indicating he's being consistent with that treatment. And obviously, he does miss his children and his girlfriend. And I do want to give him the opportunity to rehabilitate so that he can be a part of that family reasonably, calmly, and affectionately, as opposed to violently. My position always as a prosecutor to protect the public and the victims in this matter is to request that the no contact provision continue throughout the term of probation until such time as some treatment has been undertaken, particularly for domestic violence, so that the probation agent feels that he's no longer a risk to those victims. I understand that both Miss Holst and his girlfriend, Hope, wish him to be home and wish to have contact with him. Other than stating I don't agree with that at this point, I think it's too early. I'll leave that to the court's discretion. But I do feel probation with mental health conditions persistent to be an order that he be compliant with his pivotal treatment plan, and that he also be assessed for substance abuse to assure that he is not reverting back to the methamphetamine, and that we keep a close eye on that as well.
All right, thank you.
Thank you.
Just as a point, you practiced as a prosecutor in a number of other jurisdictions.
Yes.
Our general practice, I can't speak for Judge Pattison, but I think he's on my wavelength. We almost always do a no contact provision at the time of the arraignment to keep the witness safe, not have the risk of witness tampering, which is very common. Please don't do this, you're ruining our family, or outright threats. But once the sentence enters and the victim consents, I lift the no contact under the theory that there's no longer those risks and the defendant is under supervision. It's also, I understand how hard it is for the families financially, picking kids up, dropping kids off, childcare. It's also very onerous for the complainant. That's how it generally goes, but there are always exceptions, and I appreciate your concern. On the MDOP case, I'm going to do 2 days jail credit, 2 days. You got arrested on the 31st of July, and you posted bond on August 2nd. So I think you were actually in there 2 nights. 2 days credit, 2 days. in that case, and I'm waiving the fines and costs.
Thank you, Judge.
Now, it's not concurrent because it's different 2 days with the other case. So we're going to do the probation in the domestic violence case. Prosecutor, at the time of the plea agreement, believed that you deserve 5 weekends in jail. So far, you've spent 2. You spent 2 days in the MDOP incident, and you spent 2 days in the domestic violence incident. One when you got arrested in February, and another one when you got arrested in May. So you've done 2 of the 5 weekends that she requests. I'm going to give you 10 days jail credit 4, leaving 6 days to do, which would be 3 more weekends on weekends. I'm putting you on probation for 12 months. Fine is 0. You got enough stuff to pay. There's a crime victims' rights fee, a state minimum fee, $100 attorney fee. I'm going to assess just one $100 attorney fee. Well, you had 2 very capable attorneys that worked together on resolving this matter. And there's a probation oversight fee of $480 for you to pay for the class. I'm going to do the anger management class.
All right, let's talk about that. Judge Middleton ran this one with his usual blend of clear-eyed pragmatism and a little dry wisdom around the edges. The headline issue was how to sentence a defendant who had already earned a deferred outcome on a domestic violence case, but then picked up a second incident while still on bond. The prosecutor came in with a straightforward pitch. Keep the deferral in place to preserve the chance for a non-public record, but add 5 weekends in custody as a firm reminder that new trouble while you're awaiting sentence carries consequences. She also asked that no contact continue during probation until treatment takes hold and supervision says it's safe. That was measured advocacy accountability. Without trying to blow up the deal, and she backed it with practical concerns about safety, stability at home, and staying on prescribed mental health medication. Judge Middleton listened, then explained. His own practice, he often imposes a no-contact provision at the start to prevent witness interference. But once sentence is entered and the complainant consents, he usually lifts it because supervision kicks in and the day-to-day realities of childcare and family logistics matter too. It was a concise bench tutorial in how policy meets people. From there, he got granular in a way only Judge Middleton does, counting credits, stacking weekends, and making the numbers make sense. On the MDOP case, he gave 2 days credit for the July 31st arrest through August 2nd and waived fines and costs. Then, on the domestic violence matter, he noted the prosecutor's 5-weekend request and tallied the time already spent. 2 days from the MDOP case, plus 2 arrest days on the domestic case, one in February, another in May. Result, 10 days. Credit total, leaving 6 more to serve 3 weekends. Specifically so, the defendant can keep his job while still feeling the sting of a sanction. He set probation at 12 months with anger management, kept the fine at 0, and limited the extra financial hit to a victim's rights assessment. A modest $100 attorney peppered with a shout-out to 2 very capable attorneys who helped resolve it and a $480 supervision fee. That's classic Middleton. Firm structure, realistic payment load, and a path that emphasizes treatment and compliance over pure punishment. The defendant himself came off contrite and family-focused, missing his kids, wanting contact, and acknowledging mental health treatment, while the prosecutor, to her credit, didn't dismiss any of that. She simply argued, those goals are more likely to stick once counseling and probation get traction. No witnesses took center stage. This was a lawyer and judge day, with everyone staying professional and mercifully on point. The overall tone was calm and workmanlike, sprinkled with a little of Middleton's wry humor as he explained why initial no contact is standard but long-term. No contact can become a burden when supervision is already in play. If you like courts that are both principled and practical, this was your kind of hearing. A judge setting expectations, a prosecutor advocating for safety and structure, and a defendant getting a last best chance to stabilize with real consequences. If he doesn't, if you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.